here. Okay, one more.
No, that's fine.
Thank you.
Mr. Shaughnessy, good morning.
Good morning, Madam Chief Justice and members of the court. My name is Shaughnessy, William Shaughnessy. I am the respondent in the above entitled case. We are here as a result of a petition for contempt brought by Bar Counsel, alleging that while under suspension I engaged in legal work.
Well, you don't dispute that after you were supposed to suspend your practice, you continued to represent two people, do you?
I did not represent them in any legal sense, Judge. I never went to court for them. I never went to...
You never went to court, and what else?
I never took any depositions for them. I never
But
had
that's
to
not
work at
the
all.
practice. The practice of law is not confined to litigation.
Let me get into the letters involved here, Judge. I think you see that it was minimal, if practiced at all, it was at best minimal. At any rate, as I was going to say, the petition was in fact allowed by the single justice. Let me just take 7 or 8 minutes of your time and go through each one of those cases. The first one is, as Your Honor mentioned, is one of Patricia Clement. And I suggest to Your Honor, please, if you look at the suspension order, the very last language of the suspension order is that the lawyer may wind up and complete, on behalf of any client, all matters which are pending on the entry date. The case of Patricia Clement was, in fact, pending on the entry date. The only letters that Bar Counsel complains of that were part of the practice was that I sent her not on law stationery, but home stationery, a copy of a complaint that had been entered that she had an interest in, a copy of a settlement agreement that she asked for, a copy of her, not a copy, but a check that she asked for, and a letter from the to Mr. Vivaris of the Industrial Action Board about the settlement of her case. Those are the only materials that Bar Counsel complains of that I have seen in the papers. In addition, if you recall, if Your Honors look at the records, there was a motion for, after the suspension order, there was a motion for reconsideration filed, and that was my understanding that the motion for reconsideration would stay, or at least render the original judgment non-final. And I have cited, although criticized by Bar Counsel, I have cited a number of cases in my brief, page 23, 25 to 27 of my brief, laying out both that is the practice in the federal court, in the bankruptcy court, in administrative law, and in other areas of the law. In addition, I should suggest you, compared to at least the respondent in the case of in re matter of Ring, decided by this court some 7 or 8 years ago, my intent when dealing with the Bar Counsel in this case was to comply with the request of Bar Counsel. In particular, my letter to Bar Counsel back in October of 2003, my intention of complying fully and with all outstanding orders and requests. I contrast that, if Your Honors please, with what happened in the matter of Ring. Jordan Ring was in the lower court, was held in contempt some 7 times, was jailed twice. When his case came up to this court, not even some 7 or 8 years ago, that was obviously contempt, but his suspension was for 3 months. My effective suspension has been 30 months. And I respectfully suggest to Your Honors that is, should we say, unequal justice. In addition, although I do not think this issue is before you, nonetheless, one of the issues involved in the case below was in the Clement case was whether or not there was a settlement agreement made. I suggest to you the review of the record shows there was in fact a binding agreement. There was the parties in on page 47 of the appendix. The parties dealt with each other, have been trying to settle a case for some time. Finally, I spoke to the head of the Industrial Accident Board, Mr. Gregory White, and we agreed orally to settle the case. He said, get the check and the agreement over that day. The letter is hand-delivered. It was a hot Thursday afternoon in July. It got hand-delivered to him at his request. And nothing was said from him from that day to the present, if you will. But nonetheless, The check was distributed to the plaintiff. The only other communication I had was the fax that I just spoke of a few minutes ago. Some 2 weeks after the settlement, the assistant at the Industrial Action Board calls me up and says, "Could you send a copy of that agreement to us?" I said, "Sure." So I faxed over a copy of the agreement. Some 4 weeks after the settlement, a new attorney comes in and tries to reopen the case. And I suggest to you your cases, and citing particularly Dominic versus Dominic, that's virtually on all fours with that, where this new attorney comes involved and tries to reopen a settlement. That was 1 day after the settlement. This case is 4 weeks after the settlement. And I suggest that was in fact a settlement made and in good faith and binding on all parties. The other, that was with reference to the Clement case, and I suggest to you that there's no violation there. With reference to the Deborah Hussey case, Deborah Hussey case. Ms. Hussey spoke to me before my suspension. I consulted an expert before my suspension. And what her case was basically was an infection superimposed on a pregnancy. She was pregnant and she needed volume, fluid. And what they tried to do is give her volume by injecting a PICC line, as they call it, into the artery in the arm. What happened is that they took the needle from one and put it in the other without cleaning it. They used a new needle. And she had a quite extensive infection following that application of the PICC line. I consulted an expert. I was proceeding along with the case, and my suspension came. So I didn't know it at the time, but she did not. I sent her the mail that she was required, the certified mail return receipt requested. I did not know that she didn't even pick up her own mail. I did notify the insurer, so I was out of the case, not claiming any fee, out of the case. And what happened is she called me up and asked me, would I at least, because I had a basic understanding of the medical information, would I at least get some medical information for her? And I suggest to you the letters that Bar Council uses, relies on. Appendix 135, 137, 132. My letters to one is just sending her a copy of her own record from the critical care where she was treated. One is a copy of the Winchester Hospital record, and one is my request for Winchester Hospital records. I suggest to you if that's the practice of law compared to the case of Jordan Ring, I suggest to you there's a big difference. One further point I might suggest to Your Honors is this. After this court had ordered that I be suspended for 6 months and a day and to take the MPRE. Obviously, the 6 months and a day had went by in February or so of 2004. I have now passed the MPRE. I did another letter that Bar Council points to is a letter of March of 2004, which is outside the 6 months and a day. But nonetheless, you will see it's still a request for additional medical information, which, by the way, was never provided. Nonetheless, what happened in that case is that I referred her to an attorney who did, in fact, bring suit for her. The case was entered in Middlesex Superior Court. She did not cooperate with her attorney. Didn't know what, just answer interrogatories. She failed to keep appointments. And at the end of it, which you could well imagine, was a report from the Medical Malpractice Tribunal. The case has now been dismissed in Middlesex Superior Court, and I suggest to you rightly so. But she did not cooperate with her attorney, and I suggest to you there's nothing that I did with her that caused her any damage. I respectfully suggest to Your Honors, please, that as you look at the facts of the case, that there is no basis for it, but if you should impose any sentence, any penalty at all on me, I respectfully ask that you reduce the suspension to time served. As I have been, at the present time, I have been effectively suspended from September of 2003 to the present time, some 30 months, if you will, more than 30 months. And the order of this goes with 6 months and a day. I have incurred some $150,000 in defending myself, and a bill of $240,000. I paid over $150,000. I have a bill of over $240,000. I'm a single parent with 5 boys, and I need my license. And I suggest to you that the offense here, if there's any at all, is very, very minor, especially compared to the outrageous conduct of Jordan Ring in that case of Ring versus in matter of Ring. And I respectfully ask that I be reinstated in the discretion of this court. Thank you.
Thank you, Mr. Shaughnessy. Ms. Weisberg?
Good morning. My name is Susan Weisberg, and I'm here for the Bar Council. Without belaboring any points, I would like to remind the Court that this case is here on an order of contempt and an order imposing a penalty on the respondent, Mr. Shaughnessy, pursuant to a rule of this Court, SJC Rule 401, Section 17-8, by which, having been found in by which the single justice ordered, after finding that Mr. Shaughnessy had engaged in legal work after his suspension, that he could not be reinstated to practice until the expiration of a period of at least 2 times his prior suspension, so that the penalty imposed was an additional penalty of 1 year and 2 days of suspension, or the doubling of the original period, as had been ordered by this Court in Mr. Shaughnessy's prior appeal. The case really does not present any...
So that, as I understand, Mr. Shaughnessy, the period of time with which he has been, suspended from the practice to date has been 30 months, and the presumptive suspension would be 18 months, correct?
Yes, had everything gone according to Hoyle, and had there been an ordinary progression of this case with an imposition of a 6-month and 1-day suspension initially, there would have been a doubling in another 12 months. But in real life, and as shown by prior cases that I've cited in my brief, the original period of suspension often ends up being prolonged for many reasons unrelated to the initial conduct.
Well, let's just say we agree with you, and hypothetically, and say, okay, the contempt is valid and the doubling is valid. Isn't it all over with? I mean, a total 16 months, and it's now 30 months. So can't he reapply tomorrow?
If it's been a year and a day from when Judge Sossman imposed her order,
I see.
He could, except that the rule, Section 17-8, says that the doubling period begins on the date of entry of the findings, which was last June. So there has not yet been the lapse of a year and 2 days from the entry of Judge Sossman's order. Mr. Shaughnessy would be...
So the rule has a provision that covers when it ends, so to speak.
It does. Well, it's...
And let me just raise this, Ms. Weisberg, with respect to the delays, do we look to see, I understand what the rule says, and that may make sense, but do we look to see whether any of those delays are attributable to factors other than the respondent here?
The rule doesn't provide
I understand
for
the rule doesn't address it one way or the other. It says from the date of the order.
How many days, if there were a provision for credit for
time served,
how much credit would he be eligible for?
That's hard for me to answer, because when this Court reduced Mr. Shaughnessy's suspension back in the summer of 2004, he had already been under suspension for 11 months. Notwithstanding that, the Court imposed a 6-year and 1-day suspension.
6 months.
6 months and 1 day, forgive me. 6 months and 1 day suspension. The extra day having been deliberately added, notwithstanding the length of the prior suspension, to ensure that Mr. Shaughnessy took and passed the MPRE.
That's correct, and he's now passed the MPRE, and I take it you don't dispute that.
I have only seen a record that was recently been submitted by Mr. Shaughnessy in this appeal.
Well, Mr. Shaughnessy has made a representation to this Court that he's passed the
Recently, since,
It
I'm
doesn't
sorry.
matter. I'm talking about what the purpose of the 6 months
Well,
and
he's
1
got
day.
to produce the score, so if he produces the score and he passed, he passed.
Then he would pass, and I would not dispute that.
Of course not.
So that Mr. Shaughnessy would be eligible for reinstatement either on the expiration of the year and 2 days, or if the court were to fashion some kind of credit at an earlier period. But I think the point is he still would have to reapply. The reinstatement would not be automatic. And then the court would deal with the issue of his fitness. As far as the issue of credit for time served, it's hard for me to see the purpose of crediting a lawyer for time served after he has flouted the original suspension order by continuing to engage
Let me
in
turn to that, Ms. Weisberg, because I understood it from Mr. Shaughnessy today. There was a provision in the original that says wrap up your existing cases. Doesn't that create a little bit of difficulty for people who are trying to wrap up the existing cases?
The original suspension order, which is the typical suspension order entered by this court, gives a lawyer 30 days from the date of entry of the original order to wind up his practice.
Was that contained in this order, 30 days specifically?
The original one, yes. Mr. Shaughnessy then moved and got an extension of that time period. I have the dates here. I'm sorry. The original suspension order was entered on June 10th of 2003, effective 30 days thereafter, thereby giving the wind-up period. So the original effective date of the suspension would have been July 9th, June 9th, July 10th, 2003, 30 days from June 10th. A couple weeks later, during that period, Mr. Shaughnessy moved for a stay of the effective date of the suspension pending appeal. The stay was denied, but the effective date was extended until August 2nd of 2003, so that Mr. Shaughnessy ended up with nearly a 2-month wind-up period. The suspension did go into effect on August 2nd, and there isn't any provision in our statutory or regulatory scheme for winding up after the effective date of the suspension. In any event, the record shows that Mr. Shaughnessy's legal work continued long even after that date.
When you use the word winding up, is there anything in the cases or disciplinary reports that speak about what that's supposed to be?
You mean during the 30-day period?
Well, during the permitted period. I mean, is that just sending notices to your clients that you no longer can handle their cases after the 30 days and they've got to get somebody else? Or would it entail, say, you had a big settlement pending and settling within 30 days and then, putting the money in your IOLTA account and doing all the things that occur when you settle a big case? What does winding up mean?
Winding up, according to the rule, means not taking any new business during that time, but finishing, if you are able to, any business that you can finish.
Because he made it sound like, and I'm not totally familiar with the record, that he was kind of like winding up two small matters and taking an awful lot of precautions to let the people know that, he no longer could be their lawyer. Now, maybe you're right. If it extended beyond the 2 months, there's trouble there. But, there's a little elasticity in this, quote, winding up that I perceive.
There is no winding up period after the effective date of a suspension provided by our rules. Any winding up under our scheme must be completed before the end of the period. But even if there had been some elasticity, and Mr. Shaughnessy argued this to the single justice, what he did was not merely dotting a few I's and crossing a few T's. What Mr. Shaughnessy did, keeping in mind that the effective date of his suspension was in August of 2003, into the fall of 2003, in the Clement case, he continued to try to negotiate the resolution of a workers' compensation lien on the proceeds that had been awarded to his client, and he actually prepared and sent his client a settlement agreement for resolution of the lien that would have then had to have been submitted under Chapter 152.
So I take it that the winding up language may mean that I take it, A, you cannot take any new business from here on in.
Right.
And B, you can continue to work on existing cases for 30 days maximum.
Correct.
Is that clear? Is there any ambiguity?
Not that I see in the...
I mean, in other words, if there's an order that says you can wind up, and then there's a 30-day date that says the suspension is effective on, whatever it was, July the 10th, extended to August the 2nd, the suspension, right? Mm-hmm. Is it possible to read it that you can continue to wind up? You're not suspended, but you can wind up. And it doesn't, in other words, I haven't gone back to look at the order. Does the order make it clear that you can't do anything except wind up in those 30 days?
The order, in combination with SJC Rule 401, Section 17, make it clear that you can't practice after the end of the so-called wind-up period. And I'll read from the order of term suspension, which is in the Appendix 2 filed by Mr. Shaughnessy. I can't read, I'm sorry, the page number. William H. Shaughnessy is hereby suspended from the practice of law in the Commonwealth for a period of 1 year and 1 day. That was Justice Sossman's original order. In accordance with SJC Rule 401, Section 17(3), the suspension shall be effective 30 days after the date of entry of this order. The lawyer, after the entry of this order, shall not accept any new retainer or engage as lawyer in any new case or legal matter of any nature. During this period, however, the lawyer may wind up and complete on behalf of any client all matters which were pending on the entry date. That's what the language of the order is for the wind-up period.
But wait a minute. Is it clear that for existing cases, you can do no more work beyond 30 days?
I had always thought that an order saying you're suspended from practice, you have to give notice during that period, you have to surrender your files and send notices to your client saying you're disqualified from representing them after the effective date of the suspension was as clear a statement as would be required, that you can't keep working on the cases. I think it's important to keep in mind that during this so-called...
For how long? But for how long can you keep doing that?
I'm sorry. The rule says that the order says that during the gap period between the date of entry of the order and its effective date, you can do the things I've enumerated.
Okay. So once the order is effective,
That's it.
that's it.
That's it. And during that period, you are required to have told your clients that that's it. The form of notice that is in the appendix somewhere, and I'll try to find it, the form of notice that's included in the rules of the Board of Bar Overseers requires the lawyer to tell each client, I have been disqualified from acting as your lawyer, you have to get another one. Okay. I don't think it could be clearer than that the lawyer can't keep winding up after the effective date of the order. And I would also submit that what we're talking about here isn't just winding up. For example, in the Hussey case, the malpractice case, in March of 2004, which was more than 6 months after the effective date of Mr. Shaughnessy's suspension, he was corresponding with his medical expert and soliciting an expert opinion that obviously would have had to have been used for a medical malpractice tribunal had he proceeded with this case. So by no stretch of the imagination could continuing to represent a client who is unaware of the suspension, seeking an expert opinion, and misleading her until March of 2005, according to her undisputed affidavit, telling her that the case was going into arbitration, and then in the 11th hour, flipping the case over to another lawyer without her knowledge, I would suggest by no stretch of the imagination constitutes winding up. The single justice had addressed this, saying, yes, we understand, perhaps, for example, with respect to Mr. Shaughnessy's IOLTA violations.
Time is up.
Thank you.
Thank you very much.
Thank you. I rely on my brief.